Yeah, no, it's just using it because here the minimum one is
and we were picking up with Hunter and then Turcon. So Hunter and Turcon work together in terms of understanding exclusion clauses in Canada. And Hunter is a bit of a response for the Canadian Supreme Court's contribution to a discussion about fundamental breach that we saw with, from the UK, that we saw with Swiss Atlantic and photo production. What happened in Hunter?
Under to manufacture gearboxes for mining purposes, and subcontracted this to a service provider, to another manufacturer. So this manufacturer gave a limited warranty of 24 months or 12 months after the gearbox is entered service. In 2 years, the gearboxes they went defective, and Hunter had to repair them. They claimed that this sub-manufacturer should be liable, even though the warranty expired, and they claimed a fundamental breach.
Same group, the one bringing the party, bringing the action, the party bringing the action.
Yeah, the party bringing the action. So the court said that a fundamental breach is the one that deprives authority of substantially the whole benefit of the contract.
Right.
And because the gearboxes were subject to repair, we cannot say that there was a fundamental breach.
So should Hunter rely upon the exclusion clause or limitation of liability clause? Sorry.
No.
Okay. Why? What was the court's reasoning?
I think Hunter gave there was an implied warranty of fitness of the gearboxes, and the sub-manufacturer wasn't liable because the warranty period expired.
Okay.
And Hunter gave they didn't give, but there was an implied warranty of fitness, so Hunter remained liable.
Okay.
And I think the contract did not explicitly exclude the implied warranty safety of the car, so that's why they were liable.
Okay. So that it has to be a merchantable quality. Would be an implied warranty from the sale of goods act. So this case, you have it excerpted in the textbook. The Supreme Court takes arguably a different direction from the House of Lords in photo production. You recall, photo production, a security guard burns down the factory. And photo production says, well, that's a fundamental breach of the contract. And you can't exclude liability for something like that. The House of Lords says, you both signed on to this, and we're giving effect to the exclusion clause. So even though Securicor's employee burned down the place down, photo production had to bear the cost, or technically their insurance company. What we see in Hunter is a different perspective. That Syncrude is arguing this is such a bad breach that you, the Supreme Court, should not give effect to the limitation of liability clause. And the Supreme Court agrees. They say, now, it's not automatic. If you argue fundamental breach, that you automatically win. They're very careful to say that. They say it's a matter of interpretation of the contract. The difficulty coming from Hunter is that we do not have consensus as to how to interpret whether or not the exclusion clause should be given effect. We have two interpretations, one by Madam Justice Wilson and the other by Chief Justice Dixon. Do you recall what the two approaches were? It can be hard to discern what they were. So with Wilson, she's saying we should assess, we the court, should assess whether it would be fair and reasonable to apply the clause to these circumstances. Dixon says we should use a test of unconscionability. And unconscionability, as we'll talk about, would be a matter that is applied to the time of the formation of the contract. So we have two different tests being used here. So from 1989 until 2010, people were using both tests. Because if you don't have clarity, you don't show up to court and say, I like this test. You have to apply both. So then Turcon comes along. And the Supreme Court should deal with this issue and simplify it. What happened in Turcon?
They said as long as the exclusion clause covers the circumstances at issue and the clause was not
Unconscionable.
at the time of the contract was formed, the party will be bound by the clause unless they can establish an overriding policy. Public policy.
Okay,
issue.
so that's part of what the court had decided in Turcon. So factually, what had transpired here. What is Turcon about?
It was about the bidding, bidding for the.
So the court pretended.
It's a tender. There was basically, there was a process for, yeah, there was a two process, right? First, they were asking bids for, there was 6 company, and later on, a year later, actually, they were putting the tender, but with the condition that only those can get into the tender who applied at the beginning.
So remember our discussion about raw engineering?
Yes.
That this idea of only compliant bids, and there are certain obligations on the person submitting the tender
Yes.
and the party calling for the tenders.
So what happened, Brentwood was one of the 6 bidders, original 6 bidders, but he decided to go together with another company to be more competitive in the bid. So, and then the other company, of course, said that that's not fair. They're actually, in this way, another company gets into the tender who is not eligible to go to the tender.
Right.
And therefore, he should be eliminated from the...
So to be clear, we have one party, 2 parties we start off with. One is selected to move on to the second round. Once it is in the second round, it teams up with one of the parties that didn't get through. So technically, that's a new bid. And the argument is, well, that's a non-compliant bid because it wasn't selected to go on. And the British Columbia government relies on an exclusion clause in the call for tenders, or request for proposal. And that is clause 210, that states in part, except as expressly and specifically permitted in these instructions to proponents, no proponent shall have any claim for compensation of any kind whatsoever as a result of participating in this RFP, and by submitting a proposal, each proponent shall be deemed to have agreed that it has no claim. So the British Columbia government is saying, anybody that brings a claim that doesn't like what's happening, you agreed to participate in this, and you've been deemed to have accepted this exclusion clause. Obviously, the party didn't like that because it reached the Supreme Court. So at the Supreme Court, the issue was what?
The issue was that this exclusion clause can be enforced or not.
Right.
Because
But additionally, what's the test? Because with Hunter, we have 2 tests.
So here, the first select on the construction aspect true, if it's like ambiguous or not, but, and they say that this is clear and there is no ambiguity, so they can rely on the
paramount consideration of
they say
public
that the
policy.
exclusion clause
Damage.
was
Did Justice Dixon go back to being and speak about public policy? Is that what we're getting at? Because
That was more
in his,
Wilson. But public policy comes into this new test. So the short answer for Turcon is, Vinny, who wrote the decision, says, I'm going to combine everything. I'm going to have a 3-stage test now. What are the 3 stages? And there are paragraphs 122 and 123 of the decision. So the first one, as you say, is interpretation. Specifically, whether as a matter of interpretation, the exclusion clause even applies to the circumstances. So remember yesterday, I talked about this. Our first step is, does it apply? Then the second issue is, now under Turcon, was the exclusion clause unconscionable at the time the contract was made? Meaning, was there a vitiating factor that says the contract is rescinded, void, because of unconscionability? So the issue is about contract formation, not a breach of the contract. Then third, whether the court should nevertheless refuse to enforce the valid exclusion clause because of the existence of an overriding public policy, proof of which lies on the party seeking to avoid enforcement of the clause. Now, the question I have for you, is this test, how do you organize this test? Is it 1, 2, and 3, or is it 1, 2, or 3? Or. If it was 1, 2, and 3, that would be a remarkably hard test to meet. you'd have to show it was unconscionable and there's public policy. The way that Vinnie set this up is that this is, does the clause apply? Step one. Step two, was it unconscionable? If it wasn't unconscionable, then you go to step three. If it was unconscionable, you don't need to go to step three.
Such as in
Okay.
Such as in tort.
Sorry?
Such as in tort.
Just what I said, yeah. So, Turcon, you've studied enough Canadian law to notice that in Canada, we seem to like tests that have 3 parts.
Yes.
But this is different because it's not 1, 2, and 3, it's 1, 2, or 3. So it's a bit of a change on the format.
I'm just a little bit, I want to be clear whether Justice Vinnie, when he speaks about putting the coffin on the jargon of fundamental breach in one of the paragraphs, are we saying that fundamental breach is not applicable in this case?
No, so I think I gave you a quote, no, might not have. So John McCamus, who's an emeritus professor here, calls Turcon and Hunter a more open embrace of fundamental breach. That's why it's contrasting Hunter and photo production. The House of Lords, now Supreme Court in the UK, basically said you can't come to us and argue fundamental breach. That there's such a bad breach that there's no way you could say that an exclusion clause, for example, can exclude liability. The Supreme Court in Hunter didn't go that route. Because if you recall, they said Hunter lost, and Hunter couldn't rely upon the exclusion clause. Now, they didn't say fundamental breach is a rule of law. They didn't say, go ahead and argue fundamental breach. The way they phrased it was, we will determine whether or not an exclusion clause applies by interpreting the contract as a whole based on the circumstances before us. So, taking a look in particular, I say, at Wilson's analysis, would it be fair and reasonable for the exclusion clause to apply in these circumstances? Her argument is it wouldn't be, because this was such a fundamental problem. There was a manufacturing error. You can't exclude liability for something like that. Coming back to an example I used yesterday, if you put in your contract with a client, if I mess up, it's not my fault. Applying Wilson's assessment, she would say, well, that's not fair or reasonable to apply that exclusion clause abstractly. Maybe within certain parameters it would fit. So this Canadian Supreme Court is more willing to look at, in the context of exclusion clauses, that there can be something that is so bad of a breach, so to speak, that an exclusion clause would not be given force, as it was in Hunter. Now, Turcon seeks to exclude liability entirely, and the British Columbia government lost that case. And part of the reason was that the court, Vinnie, used this test. And he said there was no unconscionability here, meaning there was no issue of unconscionability, something we'll look at in a bit, at the time of formation. But in terms of public policy, there was an issue, and that's where it failed. What was the key term that's applied when looking at public policy? So I'll read it again. The third inquiry, whether the court should nevertheless refuse to enforce the valid exclusion clause because of the existence of an overriding public policy, proof of which lies on the party seeking to avoid enforcement of the clause. How do we assess the public policy? here.
Would it be fair and reasonable?
No. They dealt with it in the decision.
There was a dialogue.
So they refer back to a Supreme Court decision from 1939 that dealt with public policy and harm. At that time, Chief Justice Duff had the view that public policy should be invoked only in clear cases in which the harm to the public is substantially incontestable and does not depend upon the idiosyncratic inferences of a few judicial minds. What he's saying is, simply put, to assess public policy, the harm to the public has to be substantially incontestable. So it's cited in Turcon. It's called Reed Miller Estate, 1938, Supreme Court of Canada.
David, just again, the initial going back to exclusion clause, there was a position by Lord Denning at one time where exclusion clauses are not applicable where you have fundamental breach. That was thrown out by the House of Lords.
Right.
So in Canada, I'm not clear what the position is in terms of fundamental breach.
They're not adopting Lord Denning,
But, so it,
but they're not rejecting, they're not adopting photo production.
so we
They're
take a
saying it
different approach.
depends.
Okay.
They're saying, well, yeah, I think what they're trying to do, I know it seems maybe a bit arbitrary, but I'm trying to be fair to them. I think what they're trying to say is, maybe simply put for our purposes, and I'm putting words in their mouths, we would have decided photo production differently. I think it is what they would say. That if you hire a security company to keep your premises safe and they burn them to the ground, that's bad. And you can't rely on an exclusion clause to save you from that liability. But they don't want lawyers coming in and treating fundamental breach as a magic phrase. Saying, this is just such a fundamental breach, ignore everything else. They're saying you have to look at the contract as a whole and interpret the exclusion clause in particular with the circumstances here. That's why I started off by saying, I think where they start from when they deliberate together outside the public, I think they would say we would have decided photo production is different because of what transpired. You're asking us to apply an exclusion clause to a situation where, like, there's no gray area here in photo production. That's the case.
So the fundamental breach is more irrelevant from the circumstance of the conflict. What's the practical difference between the fundamental breach and the Canadian Supreme Court's text?
As I said, I think McCamus's assessment is that it's a more open embrace. They're not rejecting fundamental breach. They're not endorsing it. What they're saying is, what I think they're trying to do is say, look, there are certain circumstances in which you couldn't possibly enforce an exclusion clause based upon the contract and the circumstances. And my conjecture, if we take photo productions and put it in Canada, I think they're saying we probably would have decided differently on that. But they don't want, the Supreme Court has a difficult position too, because they don't want to open the door, so to speak, for lawyers to just rock up to trial level course and say fundamental breach. And it's supposed to have a meaning.
So fundamental breach is more vague?
Fundamental breach is, in Canada, a way of talking about interpreting the contract, particularly the exclusion clause, as applied to those facts, without predetermining that the breach was so bad that the exclusion clause couldn't possibly be applied.
So,
Whereas the House of Lords just basically says, there's no such thing as fundamental breach, we're going to interpret the contract. And they interpreted the contract, as you recall, on photo protection. And they gave effect to the exclusion clause. And that's fine. Personally, I don't want you to take away from it that the UK approach is better or the Canadian approach is better. What you see is two common law jurisdictions where the highest courts in each land came to different conclusions. And that's within the scope of what they can do. In England, they were giving force to what they do in England. The contract is the contract. You two are sophisticated commercial parties. You had access to legal advice. You signed on to it, live with it. In Canada, it's not as strict. There's a bit more room for argument, I would say. If you can put to the court, as in Turcon or Hunter, this just doesn't work. How could you exclude liability for something like this? So it's not as blanket an approach as the House of Lords. So in Canada, we would follow Hunter and Turcon, or simply put, Turcon. But keep in mind the 1938 decision from the Supreme Court, Reed Miller Estate, that gives us a definition of what it means when we're assessing public policy. That the harm to the public is substantially incontestable. And that may sound vague, but if it was clear, we'd be out of work.
This part is not clear for me, because I thought so far.
Which part, sorry?
So I thought so far that once you have here in this case, you had a procurement, Public Procurement Act, and you had directives which said clearly that this government has to be fair and blah blah blah.
Yeah.
So I thought this is already public policy. That was my understanding. So I thought that it's against
That's a
public
bit
policy,
too general.
meaning it's against.
But that'd be a bit too general. The Supreme Court can't make broad, general public policy questions. So I think earlier on.
Basically, if something is against statutes or directives or whatever, that's a completely different thing.
Yeah, that in this instance, the public policy determination is there a public policy reason to not give effect to the exclusion clause?
but when there is a statute, it overrides. But let's say,
If it overrid it, but it didn't in this case, right? And like, what the BC government was relying on was clause 210. Go suck it. You know, and the Supreme Court said you can't do that. Because ultimately, there is a public policy basis to not give effect to that. What was the public policy? Well, the whole thing that we talked about with water engineering and tenders and so on. You have to adhere to the rules you say you're going to adhere to. If you can just bend the rules after the fact.
But that was also in the directive. No?
They didn't necessarily rely on that.
So I'm just, for me, as from coming from civil,
Yeah.
it's just so strange that they don't even care. It looks like the
No.
court doesn't care, there is a statute, doesn't care, there is a
No, but I think
directive,
you have to
which
look at,
binding is binding the government.
but I
So-
think you have to look at, first of all, sometimes legislation is self-serving. For example, in Ontario, the government wants to take away Crown liability. Have you heard of this? So the government wants to basically take away anyone's ability to sue the government.
Legislation is usually
that would be-
self-serving, that's the fact.
That would be they could pass it, they have a majority, but a court wouldn't blindly just give effect to that. So what I'm saying is, especially in Canada,
because of constitution or
Yeah.
because of
So Canada is a constitutional supremacy, whereas in the UK you have parliamentary supremacy, because they don't have a written constitution. It's still written. Canada, the courts are basically overseeing, to some extent, what governments do. Yeah.
What I didn't understand is the case says the exclusion clause was unambiguous. So why it was unambiguous? I think it's, for me it's clear, not, it's not unambiguous, but I don't understand. Can you explain?
So, sorry, so in Turcon,
Turcon case.
who said the clause was unambiguous?
The Court of Appeal.
Okay,
Yeah.
and what did the Supreme Court find?
Supreme Court dissenting justices basically said it's also it was clear and unambiguous.
Not the Supreme Court.
And I think it's the four dissenting justices in the Turcon's case.
So they lost.
Yeah, but I mean it's what is strong dissent in my opinion. But that's why I'm saying that the clause itself is not. It wasn't
Okay, I read to you the clause.
Sorry?
I read to you the clause that they're referring to.
Yeah.
Clause 210. Arguably, that's unambiguous. It's clear what it does. They
Right.
still didn't give effect to it because of a public policy reason. So you can say the clause was ambiguous and we're going to strike it down. You can say it's unambiguous and we're still striking it down, but for a different reason. So the dissent saying it's unambiguous does not constitute a winning argument in this case, because I think we can all say clause 210 was clear. In the majority's opinion, it was just clearly wrong.
You don't mind, I still get that.
Still, it's I mean, public procurement. We are talking about this public procurement, and it's competition. Competition, bidders go into the competition, and usually in practice, I think this kind of exclusion clause is acceptable. I'm just trying to support the dissenting justices.
Yeah, and I guess what I'm asking is, to what end are you supporting them? Like, we can rely on dissenting judgments at a later date, but there has to be something important that they're bringing about. If they're just saying the other guy's got it wrong, that's not enough. And that's what I'm asking of you. What is it in the dissent that you think was better than the majority? That's the question. Zita, I'll come back to you and then
I'm sorry, I'm still getting
Yeah.
back into this interpretation
Yeah.
question. I'm puzzled. This is my last course. I thought I already start to understand common law, and now I'm questioning myself.
Yeah.
So if I understand, so since legislation sometimes is self-serving, or many times, the court will not automatically enforce it, but look into, prefer to ground its argument or findings, reasons in the principles of common law.
Yeah, so
In other cases, but still there are sources, there is a hierarchy of sources. I mean,
Okay.
if there is a law, and the law in this case was supporting the common law findings,
so
so they could just stop there, right?
in the what I take your question would be is sort of in the abstract. Do courts give effect to the legislation?
Yes, it looks like they don't care at all. I mean, I understand. For me, I thought so far that, okay, is there a law? Yes. The law is understandable and clear and doesn't have any reason to override it, then I stop there. And
Right.
if not, or it's self-serving, and I question the law, then the court has the right to go further. But it looks like they don't care at all, that there is
I don't agree with
a
that.
registration here.
I don't think that they disregard the legislation. So again, I think your question is more on an abstract. What do courts do with legislation? They can say, you violated public policy. Again, being abstract. And your own legislation shows that you're violating public policy. In the alternative, they can say, this is against public policy, and you're relying on legislation that itself is contrary to public policy. That's the point that's being drawn. So in this course, we tended to focus on what's called common law reasoning, meaning what the courts are saying. And we don't really touch on the charter too much, though charter values inform private law in Canada. So they will give effect, courts will give effect to legislation, but it's not necessarily, forgive the phrase, blindly automatic. That just because there's a statute, we're going to give effect. That's what they're doing.
But here the statute was okay, no? The statute was not against public policy. The statute was actually saying the same. What the
I
court
think so.
said.
I don't remember.
That's how I understood the case. That the statute
I think
also
so.
said that
Yeah.
that has to be fair and open and blah, 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 all this,
Yeah.
what they, thank you.
Excuse me? Go ahead.
So just to reiterate, in terms of applying the test, for the first part when we were talking about just interpretation, so if,
So
let's say,
does it apply to this circumstance?
exactly, so if the exclusion clause does not capture the breach, per se, so we could just stop the analysis right there, right?
Yeah. So my example yesterday was, if you're excluding liability for damage to property, but this is personal injury, then the clause doesn't apply.
And then if it does, then we just move on to accountability, and if that applies, then we go to or the
Yeah.
public counsel. Same thing.
I want to clarify the breach of made by the British Columbia government. Was it related to the is it related to the joint venture? Right? The breach was joint venture issue, right?
It was a joint venture by two parties, one of which was accepted to move on, the other party was not.
So can I understand joint venture in the bidding process was or was not acceptable?
I wouldn't necessarily say that. What was unacceptable was that it was a new bid. Because one party went on, and then in that second round, they teamed up with a party that didn't, that was rejected. So that was called a non-compliant bid, because it wasn't the bid that was accepted in the first round to go to the second round. It was a new bid.
But it's joint venture.
Compliant bid, that's the point.
Like, you're hung up on joint venture, I don't know why, but
It's like partnership, just
I
the
know
purpose
it
of
is.
winning the deal.
I'm clear on what it is. What I'm unclear is that this was non-compliant. That's the issue here, not that it was a joint venture.
The thing, so what I'm thinking is, in the past, in my home country, I was involved in a lot of like kind of international bid competition,
Right,
and there was a lot of joint venture, like exactly like this,
right.
like the second round.
There's no prohibition on joint ventures coming out of this decision.
And then at that time, usually they were accepted
Okay.
as a joint venture, like partnership agreement, something like that.
Okay.
But here, I mean, just
But
only a
this,
little bit confusing.
yeah, but this was not a bid that was non-compliant because of joint venture.
I think what he asked is how Because, so they were a joint venture, so how has
After the
it happened?
fact, after, so one,
And that
there were
after
two
the-
parties,
Independent.
yes.
So they were
One party
independent.
was chosen to go on, one
Yeah.
party's being told go to hell.
And then-
Go to hell, and a chosen party went together in the second round, and the other competitor said, hold on, that's non-compliant.
Yeah, I understand that, but it's, okay.
It's not about the
So in the beginning, they were separate. They were.
Yeah, I know,
from the beginning.
that, yeah.
So,
But I mean, it could be acceptable. My point is that,
no.
I understand.
yeah.
It depends on the
I understand what you're
conditions.
saying. Under different rules, maybe, but those aren't the rules we have here. And with every case, if we change the facts, you can give me another outcome. But we can only deal with these facts.
Excuse me. Before Hunter and Tercom, there is fundamental breach, right? Like the UK practice. But in Hunter and Tercom, there's a different phenomenon. It's unconscionability and public policy issue. I'm wondering what substitutes the fundamental breach in, especially in Tercom. Is the public policy or the unconscionability term? Which one replacing fundamental breach, or both of them are the substitute of fundamental breach here?
It allude, we talked about it a bit before. So first of all, fundamental breach was not converted into unconscionability or public policy.
They are completely different tests, right?
They're parts of the test for determining whether or not the exclusion clause is enforceable. Coming from Hunter, where we had two leading decisions, but no clarity as to which test to apply, public policy or unconscionability. So Vinny in Turcon said, I'm putting the two together for the test. In terms of fundamental breach, what I said was, the Canadian courts have not rejected it like the UK court in photo production. And the evidence of that, I think, is Hunter. A few minutes ago, I talked about in Hunter, my supposition, and Turcon, my supposition is the Supreme Court of Canada would have decided photo production differently. That's the one where the security guard broke down the packet. The UK said, this is the contract you signed on to it. And we're going, there's no such thing as fundamental breach, we're only going to interpret the contract. The Canadian courts are more willing, in John McCandless's words, more open to embracing the nature of fundamental breach. Meaning that there can be a breach that is so bad that you cannot, a court cannot give effect to an exclusion clause. Like in Hunter or Turcon. And that's why I say, I think the Supreme Court of Canada probably would have decided photo production differently. For the reason that if you hire a security company to keep your premises safe, and they're the ones that damage it, burn it to the ground, you can't rely on an exclusion clause in that case. Does that make sense? Or? So I sent an
Yeah, let's follow the question that because actually in the certain case, there already are three tests. But as you mentioned, the fundamental breach test is still there, it's looking somewhere else. So it means that
it's still, sorry?
it's still maybe lingering somewhere else because you said that the Canada court didn't give a very, the Supreme Court didn't give clarity to as whether
the Canadian courts will follow the English courts that's to.
They're not following photo production.
Yeah, not following photo production, but means that in
They're not
certain
rejecting
circumstances, the
photo
court is still willing to apply the fundamental test, breach test in some cases to invalidate exclusion clause.
Yeah.
So it means that actually the Tencom case, I mean the Tencom the analysis framework actually is incomplete because it's not incorporated the fundamental breach part.
Why is it incomplete?
Because the Tencom case only talk about public policy and unconscionability. So to give a full picture, actually the third route is that in certain cases, people can argue, still can argue fundamental breach.
But how?
There are three reasons to invalidate.
Yeah, that's what I'm saying though is you're repeating the point. Like you were saying, the Turcon test should have a third point. In fact, it does have 3 points. So you're asking for a fourth, and you're saying the fourth should be fundamental breach.
Yes, yes. It means that,
But that
when the judge issue the judgment, they should have the full information in their mind. Why they not mention this possibility that?
how is the Turcon test not about fundamental breach?
Because actually, for the majority, actually, the case is decided on the construction of the exclusion clauses. And
How's that different from Hunter? They're both talking about fundamental breach. You don't need to have a line in a test that says, and there should be a fundamental breach. This test is talking about what has been called fundamental breach. Fundamental breach, let's be clear, isn't a horrible term. It's a silly term that I think our discussion very much shows is unhelpful. And I blame Norte. Fundamental breach, again, and I apologize for those of you that understand this. Fundamental breach is an argument that says there are sometimes breaches that are so bad that they just automatically mean you can terminate the contract. In our specific context here, you cannot possibly give effect to an exclusion clause. The UK courts did not accept that. Arguably in photo production, that would be a prime case where you say that was an instance where it would be against public policy to use Madam Justice Wilson's language to give effect to that exclusion clause. But all of this is a discussion around this curious phrase of fundamental breach. So the Turcon test is an assessment of what has been loosely called fundamental breach, but put in maybe better language is a test about when do we give effect to exclusion clauses. So why is it that clear?
Just a question for you, like, you're going and tapping in circles, like, you know, it's obviously hard to grasp what you're talking about. So for the Institute of Fundamental Breach, there has to be a breach, and there has to be an exclusion clause. Is that correct? Any breach of the contract, in the sense of primary obligation, is a breach. You sue for whatever you can do, damages, you can, rescind the contract, go for damages. You don't need to prove that the breach is of fundamental nature because the primary obligation cannot be fulfilled. That's the nature of the contract. That substantially deprives you from the contract. But in a sense of the institute that we are learning today, we have to have a breach, which is tough. And we have to have an exclusion clause, which is tough. I understand. Then, this Institute of Fundamental Breach explains to us that if there is a clause which is really inappropriate, and the breach was really inappropriate, the exclusion clause, the clause that limits liability, would never be implemented, no matter ambiguous or non-ambiguous or whatever means.
So I didn't even think it was that layer. To me, it's sort of much more simply put. Most contracts have exclusion clauses. So if there's a breach and somebody's relying on that exclusion clause or limitation of liability clause, we have a test that tells us how to engage with whether or not it's enforceable. And the enforceability, a factor in that interpretation and assessment is what are the facts. So fundamental breach, as I said, is this confusing term that is Lord Denning thought was a clever way of summarizing that there are just sometimes things that are done that are such a bad breach of the contract, you don't even need to litigate. It's just so clear. And that's not the case. So there's not this idea of a fundamental breach. What we're doing with fundamental breach is looking at exclusion clauses. And in particular, we're looking at, is an exclusion clause enforceable? So, yeah.
David, my take on Turcon, and reading some of the journals on this case, is that it appears as if the Supreme Court has laid to rest fundamental breach, and Justice Wilson has stated clearly that somehow it's replaced with a pre-breach unconscionability, and the issue rests with interpretation rather than as a rule of law with fundamental breach.
It wasn't Wilson that talked about unconscionability.
Or Dubé, one. Dixon, but it was reiterated by Wilson. And I'm reading clearly from here, and some of the journal articles. So I'm a little bit taken aback when you spoke of the Osgood professor speaking of this openness to fundamental breach now in Canada, or hugging up to fundamental breach. So I thought we were drifting away from that rather than...
No, I don't see how you got that. Because they haven't, so it can be an interpretation that the Supreme Court has laid to rest fundamental breach. But I don't see how that could be. I don't think what they have done is leave the door more open, which is what McCandless was saying, than the House of Lords in the UK for this kind of argument. The House of Lords in the UK is saying, we're going to give effect to exclusion clauses. You can't tell us otherwise. That's very reductive, but maybe it's a better way to look at it here. Whereas the Supreme Court of Canada is saying, we're going to consider whether or not an exclusion clause applies. Yeah.
Go ahead.
Can we say that the court still, or trying to say that we still agree, or we still gonna take the fundamental breach argument, but it's not enough by itself. You have to prove more than just like a fundamental breach in order to void the limitation clause.
Yeah, except they're saying, instead of telling us fundamental breach, you're talking about interpreting the contract and whether or not the exclusion clause is enforceable in these facts. So that they don't, neither court wants people using the term fundamental breach because, as the past hour has shown, it's a confusing term. And it doesn't mean anything useful. All this is about is interpretation of the contract with the exclusion clause based on the facts before the parties, or the court in this case. So fundamental breach, I would say, don't be concerned with what that means. I think that will lead you off in an unhelpful direction. It's more about fundamental breach is this poor term for referring to interpretation of the contract when we're looking at an exclusion clause. And that test is the Turcon test, the three-part test outlined by Vinny. Now, what I was going to say a few times ago was I sent you an email. Sorry?
Yukon case.
Yeah. What I'd recommend is, not for tomorrow, we can come back to it next week. Take a look at mega reporting?
Mega reporting.
Ever since Trump did MAGA, every time I see mega, I think it's MAGA. Mega reporting. Take a look at it, because in that case they say, no, this wasn't substantially incontestable. So they gave effect to the exclusion clause. So what you have is Turcon that says it was substantially incontestable, the Yukon case saying it is not substantially incontestable. And what I'll preface all that with for you is, when we're looking at exclusion clauses in the Turcon test, I think it will be very rare that the unconscionability test or unconscionability stage will be the end point. I think most of the cases will be dealt with on the public policy stage, the substantial incontestability assessment. So what I'm going to do is I'll talk generally about frustration and mistake until the break. And then we'll do duress and unconscionability after the break. Because duress, I think, is fairly straightforward, although I think I'll be proven wrong, maybe. But I want to leave time for unconscionability, because that's your assignment. And I assume you want to discuss some points about that. I can't give you, I'm not going to say interpret it this way or that way. Okay. Because I think right now with the Heller decision, unconscionability is kind of open. But I'm happy to sort of bring things together, clarify points surrounding it. But the direction in which we're going, that's for you and your assignment. So what we're talking about with duress, unconscionability, mistake, and frustration, these are vitiating factors. Vitiating factors, as we already touched on with Turcon and unconscionability, are reasons that would nullify the consent given at the formation stage. So, if we use the example of economic duress, because we've looked at it before with a couple of cases, if someone says, pay me more or I won't perform the contract, that is economic duress. And the court will say the obligation to pay more is nullified because there is no true consent given. It has to be voluntary consent. That's the hallmark of contract. Parties voluntarily entering into mutually agreed to obligations. What we're dealing with mistake and frustration are two particular instances. Let's look at frustration first. Have you heard of frustration or force majeure? So what have you understood that to be?
The party was not able to enforce the obligation because of the reason out of their control, such as a war or something similar to that.
So something outside of their control that was unforeseeable happening.
I was going to say that same thing.
So, Frustration deals with these circumstances that are beyond the party's control. It wasn't always that way in the common law. We have the case from several centuries ago called Paradigm versus Jane, where this guy rented land and it was occupied by the king's enemy for 2 years, and he still had to pay rent for those 2 years. The contract was not frustrated. That has been relaxed. But frustration still remains an example of how, what I talked about before, how the courts are reluctant to let parties out of their obligations. So if a party says, I can't perform this construction contract because there's a labor strike, the courts generally will not accept that, because a labor strike is not something that's unforeseeable in the construction industry. It has to be something that is truly unforeseeable. So it may seem a bit harsh, but frustration is an example of what I've been talking about with the importance of formation. The courts will be harsh with these vitiating factors because they don't want parties, say, coming up with these reasons, what they might call, the courts might call excuses, to get out of their contracts. So a good example, I think, is the Super Servant 2 case. In this case, the party renting the ships out, they have 2 ships. And they say to the charter party, which means the party renting the ship, we will give you the Super Servant 2. We will rent this ship to you. And Jul30 versus Miller, the Super Servant 2, if you're looking for it. But I'm giving you the facts, the reason anyway. So there are these 2 ships that they have. They say to the charter party, the renter, we will rent to you Super Servant 2. Super Servant 2 sinks.
Do we have the page number in the book?
Super Servant 2 sinks. Is that a frustrating event, do you think? You don't have to read the summary. What do you think? The sinking of one of the 2 ships, the one that they're going to rent to the charter party.
It's not the frustration.
Sorry?
It's not the frustration.
Why?
Well, it's natural for the ship that it can sink. It's part of its life.
Okay.
It's foreseeable, right?
And it's
Foreseeable.
foreseeable.
But also the court said, you have another ship. The ship owner will say, well, I've already allocated that to another party. The court says, doesn't matter. You're going to breach a contract. It's up to you which one. This is an example of the strictness of the common law in terms of vitiating factors. The concept coming out of the Super Servant 2 is called self-induced frustration, where you created the circumstances for the frustration. So the court, through this concept of frustration, is saying there will be circumstances that truly are frustrating. No pun intended. But generally speaking, we're not going to let people out of agreements based on frustration. It's going to be narrowly interpreted. Then we have mistake, another vitiating factor. How do you understand mistake in contract?
It's a mistake of the facts, rather than anything else.
Okay. Sorry?
Understanding mistake in terms of understanding the facts, for example.
Yeah. So there's this classic the classic case you will often hear about, maybe you studied it in foundations, is Smith versus Hughes. This is the case about oats for horses. So in Smith and Hughes, you have somebody selling oats and somebody buying oats. The mistake was, what kind of oats were they? So again, I'm just talking generally right now to give you an overview of the concept, so we have open up time for unconscionability and the rest in the second part. In Smith and Hughes, the court basically said this has to be retried because the seller thought he was, I may have reversed this, but the seller thought he was selling new oats, the buyer thought he was buying old oats. You may ask, what's the difference? Well, it turns out new oats make horses sick, and old oats are okay for them. Something like that. So there is a significant difference with the nature of the oats. That's sort of the classic example of mistake. Now, what I'm going to refer to is under the heading mistake as to identity. And I'm going to talk generally about what we might call the fraudster cases. In contract law, there's a distinction made in how mistake is treated depending upon whether the contract is formed face-to-face or by correspondence, not face-to-face. And the common law treats the face-to-face contract more harshly than the alternative. Why would that be? I'm asking rhetorically. This is another example of the common law taking a strict approach to vitiating factors. Basically, the common law is saying, wait, you want us to say, to understand that you contracted with someone face-to-face who turned out to be a fraudster, but you didn't intend to contract with that person. And you want us to void the contract, meaning make it as though it never existed. The problem with that is that it can set a precedent for people to try to get out of agreements. And so the courts take a narrow view on these, and they say, so we have the case of Phillips versus Brooks and Lewis versus Avery that say, okay, if someone defrauded you, let's say you own a jewelry store, and a fraudster comes in and says, I'm so-and-so, a really wealthy person, and they show you ID and so on, and you sell them jewelry, and they pay by check, let's say, or credit card. You have to go to the court and say, well, I didn't intend that. Oh, no. The best the court will do is render that contract voidable. So what we're looking at is the difference between what's void and what's voidable. And I think you have these concepts in civil law as well.
Yes.
So void means it never existed. The Latin phrase void ab initio. Voidable means it still exists until you go to court and set it aside, that contract. The problem with voidable is that in my example of the fraudster that bought jewelry from me, a good fraudster will have already sold that property on to a third party. So you won't find the fraudster, but you might find the innocent third party that bought the jewelry from the fraudster. They know nothing about the fraud. So the courts, generally, the cases have gone that the third party gets to keep the property. And the vendor, you the jeweler, are out, you have the loss. Because in that time period, if the contract is voidable, the property is passed on. There's still title to the property in the hands of the fraudster. Now, I use the phrase third party. The third party has to be someone who bona fide is a third party. So in London, recently, London, England, there's a big industry where people have their, what we call cell phones, or mobiles there, are stolen out of people's hands while they're walking down the street. So it's usually a team of two people, two on a moped, one driving, one stealing. I use this example to say that there are circumstances where you could not be a good faith third party purchaser. For example, if somebody on a moped in London comes up to you and says, do you want to buy a cell phone? Let's say that's not the orthodox means of purchasing a cell phone. So you have to know something is off there. So that would be the only way to really attack this face-to-face contract in a mistake of identity issue, where you're dealing with a fraudster. You would have to prove that the third party basically wasn't a good faith purchaser. Otherwise, the property is basically gone. And it seems harsh, as I said, but as I said, the court is concerned, the common law courts are concerned with the precedent. The people will use this as an opportunity to get out of contracts they just don't like. We may disagree with it, we may think that's harsh, but what I'm saying is the courts have made this decision that they're going to put an emphasis on formation. Once you've agreed and fulfilled the formalities of formation, we, the courts, are going to be unlikely to let you out of a contract for a vitiating factor. The other idea is by correspondence.
So,
Yeah.
in Ingram versus Italy, there were two sisters who accepted a check from someone.
Yeah.
And this was a
Could I
case.
interject? The Supreme Court overruled that decision. In a case we'll deal with in a minute. So, contracts made in writing, where you don't see the individual. The courts treat that differently. If you can show that the other party was a fraudster, you can convince them that the contract should be void. Meaning, you don't have to worry about the good faith third party purchaser, because the good faith third party purchaser who bought the jewelry that you sold by correspondence, let's say, has to give it back to you. Because the fraudster didn't have title to the stolen goods to pass on to a third party at any point in time. So, Constantina's question about Ingram was dealt with in the Shogun Finance versus Hudson case. In Shogun Finance is, I say, a very interesting case because I think it consolidates what I've just been talking about. So I'll give you the facts sort of abstractly. somebody pretending to be Mr. Patel comes into a car dealership. He has the license and identification of a Mr. Patel. Turns out they're stolen. And he wants to buy a car. The car dealership says, okay, well, let's go about doing it. The fraudster says, well, I need financing. And the car dealership says, well, we just so happen to have an arrangement with this company called Shogun Financing. So the car dealership sends the paperwork over to Shogun that shows the Patel's ID and so on. Shogun looks up Patel, sees that he's has a good credit rating, and extends the financing to the fraudster, who they think is Patel, the real person. The car is sold, and the fraudster leaves with what it turns out to be stolen property. Is this a face-to-face contract or a contract in writing by correspondence? Why?
The financing company did not see this
Right.
in person. They were only able to examine the document that they got.
So the contract was made not with the car dealership, but Shogun Financing and the fraudster, who never met. And because of that, the contract was void, car gets returned, etc. Shogun Financing. So in Shogun, in the course of discussion, they say, ignore England. What we should look at, they say, is the case of Lewis versus Avery. That was a properly decided case. Follow that precedent. So I know I've given you a brief overview of these two vitiating factors, but I hope it gives you an idea as to what they do. But also to underscore the point that I've been making for the last while, that the vitiating factors underscore that the common law courts are reluctant to let parties out of contracts. You are not likely to get out of contracts with vitiating factors. There's a bit more of an opening with something like misrepresentation, and we'll see that at the end. But generally speaking, the courts want to keep parties to the agreements that they have made. So I'm happy to take questions when we come back from the break, but we'll come back, do duress, economic duress particularly, and then unconscionability. And let's say we come back at 8. Start with the Williams and Walker brothers decision, because we've looked at that before. I flagged at the time that we looked at it in consideration that we would come back to it because there was this argument about economic duress. No, Williams and Rolfe brothers. Lieber brothers is a mistake. So we're looking at economic duress. So I'm trying to pick, using the time we have, pick cases that are familiar at this point to illustrate points. So Williams and Rolfe brothers, we know, was the case that found this concept of a practical benefit in terms of consideration. But we talked a bit about it at the time, but it's worth coming back to now. Rolfe brothers argues that there was economic duress exerted on them by Williams, and that was another reason, other than a failure of consideration, that was an alternative argument for why there shouldn't be a binding obligation to pay Williams per unit in addition to the originally contracted price. Why did that argument fail?
Because the offer came from William, roughly, yeah. So William didn't offer Rafi to be paid like an extra amount of money. Instead, like the other party offered to them to pay the extra amount of money in order to finalize the construction on time and avoid getting charged as a charge from the
Yeah. So the key distinction was Williams did not say, I'm not going to perform unless you pay me more. The case just above Williams in the notes, Atlas Express and Capco, shows that where you do make that threat, then it does amount to economic duress. But we've seen a case already in Canada that shows that. That's the NAV Canada versus Fredericton Airport case, where it was shown that NAV threatened to breach the contract in order to get Fredericton Airport to purchase the equipment needed. So the idea of economic duress is that you were coercing the other party to consent to enter into this agreement. So what I've tried to outline is how do we look at that? So as you go through the cases, I've given you the two elements: pressure amounting to compulsion of the will, illegitimacy of the pressure exerted. And let's see the Canadian cases on this. So Canadian reception of the doctrine, we have DeWolf and Mansour. Let's look at Stott versus Merit Investment. Stott versus Merit Investment is a decision where there was economic duress, but it didn't void the contract, vitiate the contract. So why was there economic duress in Stott?
I think because the employee signed that he would be responsible for recovering the loss, but he did so maybe out of fear of losing his job.
So he was coerced to consent to this arrangement.
Yes, because he was advised that he did not sign the agreement, things would not go well for him. So this is at the firm. So this is economic duress.
Right.
Because he was, at that time, we may say that he did not have an alternative. And he did not sign voluntarily. But then, his subsequent conduct amounted to an affirmation of the agreement.
What was that? So an affirmation means there may be something wrong done. For example, here, there was economic duress. But if the innocent party then carries on as if, well, there's an agreement anyway, the court said, well, you have affirmed the agreement. So that takes away the argument that there was economic duress. You cannot sue any longer based on economic duress. So do you recall why subsequent conduct amounted to an affirmation? So the reason was he hadn't tried to disavow himself until several years later.
It's kind of like accepting the situation and like proceeding
as if the agreement is in place.
Yeah.
So I don't remember the exact number, but let's say Stott was coerced into this agreement in 2010. Then in 2015 he says, hold on, you economic duress me, that's not proper. And the court says, you can't, that claim is illegitimate because you affirmed the contract. Yes, there was economic duress, but because of your affirmation, you can no longer set aside the agreement. Now, the last case in the notes I gave you, Greater Fredericton Airport, brings up the question, what is the test for economic duress in Canada? Is it that two-part test that I applied with from Lord Scarman in Universe Township, or is it this new test from Greater Fredericton, which I think I gave you at the end of the note? So what would you do if you're presented with an economic duress argument? Doesn't matter which side you are, plaintiff or defendant. How would you approach this question of which test to use? Oh, yeah. So where it's unclear what test to use, when you come to court, you have to be prepared for both. So your submissions have to deal with both. The worst thing to do, I would say, is to show up to court and the judge says, well, I like the other test. And you say, I don't. The judge always wins. So you have to be fully prepared. It means extra time spent, etc., more money spent by the client, but that's how you have to look at it. Now, what you can do with the two tests is try to convey to the court that you think one should be preferred over the other. For example, you could say, well, the Lord Scarman test, the two-part test, it has been applied much more frequently. We don't have a lot of case law with the New Brunswick case. Maybe that's what you say. So you can try to guide the court into which one to apply, but you have to be prepared for both. So economic duress is about the time of formation, and it brings up the question, was the consent voluntarily given? And in particular, why we call it economic duress is it's not literal duress. If you put a gun to someone's head and say, sign this or I'll kill you, that's duress, sort of classic duress. Economic duress is where you are coercing someone through, usually the facts are, you threaten to withdraw performance, or performance, you say, pay me more until I won't perform. So economic duress is about the consent to the contract not being voluntarily given. And therefore, the contract is invalid, it's rescinded. Because there isn't consent. You didn't voluntarily enter into that contract. So here we see the grounds upon which, in terms of vitiating factors, the common law courts will accept when parties can be let out of their agreement. But if you think about it, this is pretty extreme. Somebody who threatens not to perform a contract unless you pay them more, that is an extreme circumstance. And as we saw with Williams and Rolfe brothers, arguably you don't even have to do that. You don't have to threaten it. You can, as I said, if you recall, with consideration, you can kind of massage things in your favor. If you're in construction, you can take a bit of time and say, oh look, we're not going to complete on time, and let the other party, as in Williams, freely offer more money to get it done on time.
if the other party offers and no mind, then we usually don't have to rest.
Right. Which is kind of crazy, if you think about it. Because somebody who's savvy can create the sort of winning conditions. And as I said before with consideration, I think the construction industry is a good example of where this can happen. We can see it plausibly occurring. No offense to the construction industry. Yeah.
With regard to employment contract, where you have an employee who signs an agreement under economic duress. And
With
then-
Stott, you mean, or something else?
Let's say in general, signs something that maybe surrender some of his rights or something. And then he continues to work and does not protest
Yeah.
because he basically needs a job. And then his employment is terminated, and then he,
It'd be a bit different, like
because we could say that the situation of duress continued until.
yeah, there's a concept in employment law called constructive dismissal, where, let's say you're demoted, but you continue working at the job. A very traditional contract law would say, well, you affirm the contract, you affirm the demotion. But employment law will say, well, in practicality, people need to work. So there's this idea of constructive dismissal, that you haven't officially been dismissed, but you've been demoted, and that has the effect of dismissal, and you're seen on that basis. So it is treated a bit differently in employment. Yeah.
Sorry to take you back. Please, I just want to know which are the two tests you're referring to.
I said, I wasn't referring to either one. I was saying we would apply both.
And when you say both, meaning?
The one from Fredericton and the one from Universe Tankships, the Lord Scarman two-part test. So in the notes, I had elaborated on the two parts. I'm just scrolling back up. So Universe Tankships of Monrovia versus International Transport Workers. There's a two-part test there. And then I go on to separate the two parts and show cases outlining both parts in the note.
On the same topic, I wanted to ask it earlier, but which is the House of Lords decision more persuasive than a provincial or provincial court of appeal? It's in the Canadian court, obviously.
Offhand, usually you prefer the Canadian court.
That's what I.
But it's not something that I say as a rule, because the reasoning will be looked at. So if the law, let's say the Sale of Goods Act, because the Sale of Goods Act in Canada is largely similar to the Sale of Goods Act in the UK. So if they're interpreting similar provisions, but the BC Court of Appeal, their reasoning is a bit flawed, you have a case from the UK Court of Appeal even, you can just say, well, maybe the UK Court of Appeal would be the one to follow. So it's still an open question, is what I'm saying. It's not absolute, but generally speaking, you would think something within the jurisdiction would be better than outside.
I mean, clearly a House of Lords decision would carry more weight than an appeal court from one of the provinces in the normal course, but there's the home ground advantage or disadvantage. So it is the home ground advantage that the appeal court of New Brunswick would have over the House of Lords.
But see, in that case, if that's your question, I would say that with economic duress, I think courts would probably go with the House of Lords decision. And commentary has been critical of the New Brunswick decision on that point. So, in what I was saying before, you part of your argument may be, well, I've shown you how the test applies to our facts from the New Brunswick case, But I think we should be more consistent and follow the House of Lords decision, because that has been what the law is across Canada, let's say. There's been more cases decided under it. That's what I was referring to earlier when I mentioned that.
I can't think about facts now, but generally speaking, can an argument pass the one test and fail with the other one?
Theoretically, yeah. That's when you have a problem.
So, we have to, you said that we have to prepare for both of them. But if we want to argue, if we have the innocent party and we want to argue economic duress,
Yeah.
we have to choose the one that is more.
See, that's the problem. If you choose the one that's more advantageous, this is getting into sort of a strategic point. I think you're leaving yourself open to a problem. Ideally, even if it's not as solid, let's say you pass one test clearly, the other one a bit. It's a bit iffy. You still want to show you clear both tests. And that's when you might say, well, I think we should follow the one that I'm stronger on. You wouldn't say that. But that's more of a strategic point. Ideally, you pass both. And if you don't clearly pass both, you want to make it look as close as possible that both apply regardless. This is just such a clear case that it doesn't matter what test it applies. It's kind of the thinking. Any other questions about economic duress?
So the first test starts with which place?
Universe tankships?
Program.
Yeah. And then if you see just below that, the bullet points, I put down Boris Sparman's two elements. I have element 1, and then later down, I have 2. So I've applied them for you in terms of giving you cases that support each stage. Which, going to the question earlier, I think makes it easier to say, well, I think we should follow the universe tankship space. It has more legacy behind it. I'm not trying to steer you in one direction. I think when there's the New Brunswick test has some difficulties. I think if we have more time, we can go into it. But I think just the simplicity of the universe tankship space test is something that goes in its favor. So
It doesn't matter that this airport case is much newer. I mean, it's nearly 20 years different.
Yeah.
Doesn't matter?
No, it's not that it doesn't matter, but the age alone, isn't that what people say about redundancy? To get rid of older people first?
Yeah.
I wouldn't say age is a determining factor in
No.
that case, as in here. So,
Let's see, this is a Canadian one, and the other is not, right?
I understand, but,
I'm just wondering, I'm not.
yeah, but what I'm saying is, I've been consistent on, I'm not saying disregard the New Brunswick case. I'm saying you apply both tests. And I said further, you could argue in applying both tests that the court should continue with the universe tankships case because there's more weight behind that in terms of jurisprudence. That was all. Unconscionability. So my expectation is that you're fairly fluent with unconscionability. You may not be comfortable with it, but you're fairly fluent with it. So I'm going to start with the Macaulay case, because I think the Macaulay case really stands out. This is a House of Lords decision, and it's about a young songwriter that basically had to sign over his life plus any children to the publishing company in order to get his record made. And the court said this was a one-sided agreement offered on a take it or leave it basis, and it was unconscionable. So let's tease that out. Why would this be unconscionable? Well, we have an individual who, not just because he's young, but with young we mean he's inexperienced, he doesn't know the music industry, he doesn't know commercial endeavors, and he's contracting with a sophisticated commercial party, somebody who's in the music business. So we already have, to some extent, he's unknown. So he clearly has every reason to sign up with the first person that offers him an opportunity. It's one-sided. Basically, the music producer says, here's the only agreement I'm going to offer you, take it or leave it. So there's no opportunity to negotiate, nor is there really any reasonable expectation that Macaulay could negotiate, really.
Is it like standard for contract?
It could be kind of like that, yeah. So the music producer was taking advantage of this imbalance and doing so in a way that created a bargain that was lopsided in its favor. So here we've sort of outlined some of the characteristics coming from Macaulay. As I say, this is a unique case in terms of the cases we have because it's really the only one that deals with unconscionability on a substantive level, what I call a substantive level. The others are, I would say, a bit more procedural. What I mean by that is Macaulay was not like in Harry and Crooksinger or some of the other cases, was not somebody who was of low IQ, wasn't somebody who was elderly, unsophisticated. Those are the Canadian cases that we generally have with unconscionability. There's something improvident about how the defendant dealt with the plaintiff because of the plaintiff's incapacity in some sense. Macaulay is different from that. He doesn't have a mental, an IQ issue or an age issue or elderliness or anything like that. He's just a regular guy who wants to make music. And that's what I see as a distinguishing factor from these other cases that we have. So the test I've given you, court's can intervene to rescind contract whenever it appears that one of the parties was incapable of protecting his or her interests, and we have some examples, and two, it was an improvident transaction. But generally speaking, the incapability of protecting his or her interests has been somebody who is of a certain class of person. What I mean by that, again, is low IQ, elderly, maybe has lived rurally for a long time, isn't well versed in commercial matters at all. Not necessarily like in Macaulay, where we could say he wasn't well versed, but there was more of an imbalance of bargaining power. We don't see that necessarily in the other cases. what shows us that there's an imbalance is the low IQ or the age. We didn't have to do that with Macaulay. So I find generally the cases that we have under unconscionability to be kind of unhelpful in terms of they give this impression, if we go back to the Turcon case and the Dixon line that was added in by Mr. Justice Biddy, if the contract was unconscionable. If you recall, I said in the first half, usually that won't be the argument. And this is why I'm saying I don't think unconscionability would usually be the argument. Because you have to prove that the plaintiff is somehow a vulnerable person in some way.
But if he's not vulnerable, but compared to the other person.
But that's an imbalance, and that would be like the Macaulay case. But Harry and Krutzinger and so on, there was something more.
So you mean that if in Canada we haven't addressed and established where some similar to the music case, so this is why
it's been narrowly interpreted. What is unconscionability? Well, you have to have a plaintiff that is vulnerable in terms of age or frailty, mental.
So it's narrower.
Yeah. So I've given you the Downer and Picture case and then Tellis and then Heller. The reason I give you those is, well, I hope Downer sort of helps give a bit more of an expansive interpretation, but Heller in particular, I think is really arguably opening this up. Heller versus Uber Technologies. The case you're supposed to write it on, or at least refer to. So Heller I find very interesting. The first case from the Superior Court of Appeal this year. And it really begs, I think, an important question. And that is, how useful is unconscionability as an argument regarding vitiating factors in contract law? So the facts of Heller are a bit like the Macaulay case, because Heller, we're dealing with Uber drivers. So Uber drivers sign up to these agreements. And I personally find this a bit outrageous, the terms that they had to sign up to. And I think I gave you, I gave you the numbers as well to this, I think. That if they have a problem with Uber, they don't take it up here. They go to Amsterdam. And not only that, but everything is under Dutch law. I have no idea why. I asked a Dutch lawyer about this, and he said, I have no clue why. I think they were just trying to make it as hard as possible or disincentivize Uber drivers from bringing any sort of thing. So they have to go to Amsterdam, their own cost. Dutch law, obviously hire a lawyer. But then they have to go under the ICC rules.
I think there should be an arbitration, right?
Yeah. So this clause is, how would we characterize it? Usually it would be referred to as a dispute resolution clause. Remember, in certainty, we talked a bit about this. But it's more than that. It's actually a forum selection clause, meaning it's saying what law applies, and it's a foreign jurisdiction that really has no tie with the parties. And the costs are just something outrageous. What was it? ICC arbitration rules. Drivers will be required to pay a non-refundable filing fee of $2,000 US to initiate mediation proceedings. If the dispute was valued at under 200,000, an additional fee of 5,000 US will be applied. Then the cost of initiating the arbitration process, you haven't even had your case heard yet, was found to be approximately 14,500 Canadian. And in this case, Heller made between 400 and 600 Canadian a week. He didn't even, with 1 week, he couldn't even go to mediation. So the point I'm underscoring here is, if we're looking at something that's in balance, doesn't this represent the classic example of imbalance? If Uber had put all these in, but it was Ontario law and through an Ontario process, maybe that would be okay. But I think just by putting it over to Amsterdam under ICC rules and Dutch law, I wonder if that pushed it just to an extreme that.
I have a question. So, it's a tricky question. So, for example, this Uber company, isn't it located in Canada? So then the problem would be.
They would have a subsidiary here.
But the main.
Their European headquarters, I think, is in Amsterdam.
So the headquarters is like in Dutch or?
No, what I said was, I think the European headquarters is in Amsterdam. But as far as I know, Uber is based in California. Its headquarters.
Ancestors like European countries, so they may have said that you have to go to California to make the arbitration, but like going to Europe doesn't make any sense.
Well, this is what I'm saying. So if we're talking about unconscionability, Heller, the facts will seem to tick these boxes of something that you would have to say is improvident, or at least I shouldn't say it like that. There's a question of improvidence. Just using the lopsidedness of the relationship to, in this case, Uber's advantage, but to a real extreme extent. Because Uber has its offices in Amsterdam, it'll have its lawyers over there take care of it. Heller, who makes between 400 and 600 Canadian a week, has to get over there. And Air Canada's not cheap. The WestJet, yeah, I wonder if you'll get there. So, everything is on Heller and the other Uber drivers here. Now, what I want to make clear, you might have read before about the big issue with Uber is whether or not the drivers are employees or independent contractors. That's not the issue here. That is separate, and I'm not asking you to look into that, don't bother with it. This is purely taking from the perspective, if we accept Uber's argument, that Uber drivers are themselves their own small businesses, where you have two commercial parties contracting, can unconscionability be used in this kind of a scenario? How viable is it? Because I don't think we even get necessarily an answer from the Court of Appeal. I would argue we don't even have a clear test from the case as to unconscionability.
Yeah, I want to be a bit contrarian about this decision and perhaps Macaulay and maybe ask a question that kind of strikes to the heart of this notion of unconscionability. But on what? I struggle to understand what effectively is a very paternalistic approach. I've used that word before. There's nothing, firstly, the Uber drivers don't have to enter into this contract at all. They can find some other form of employment. Or alternatively, they could have obtained legal advice, before concluding it. They could have attempted to negotiate terms. I know you'll say, well, they didn't really have a choice. Well, actually, you always have a choice.
I would be careful to say you always have a choice. I think
Well,
economic duress shows that.
You can go work in, you know, Tim Hortons or
In
whatever
terms
else.
of an Uber driver, you don't have to be an Uber driver. is the point.
But exactly, but earning $400 to $600 a week, one could do in probably a number of jobs. It's what, $25,000 a year. The same argument in relation to Macaulay and this. Where's the responsibility of the poor individual who's suffering this duress
Yep.
to actually obtain legal advice? What was stopping Macaulay from actually, there are free services available even for non-criminal matters. This was 1974, maybe not
Yeah,
so
not now.
sophisticated. But I just have a fundamental difficulty with courts wanting to jump to the assistance of individuals who really, you know, have a choice to make ultimately, and we're not really respecting the contract that they've actually made.
Okay.
But
Like, I'm not going to answer it because it's your paper. And, like, if you're asking, is that a line of
To
argument
argue.
I can use? Sure. I think you just have to be aware, like as I pointed out as you're going along, don't overstate things. They do have a choice. I guess the alternative is, you know, should the courts then say, basically endorse freedom to contract?
that's why I put it as, I said it's actually strikes at the heart of freedom to contract as you choose to really. And I get the strong sense from this course so far that courts are going to bend over backwards to actually really assist what they see as vulnerable plaintiffs.
Maybe, and like, that's why I've located it in Canada, because in Canada it's more likely than the UK, and we're dealing with Canadian law. But
we did see those cases yesterday, the Seeds case and what was the other one?
sure,
The-
but like, I think we have a difference of opinion on George Mitchell and Finney Lock Seeds, which I'm not going to repeat.
No.
But with Heller, I think there's a real question. Even if the courts want to, in your words, bend over backwards to help vulnerable plaintiffs, how can they do that with the state of the law of unconscionability? How viable is that? So here, they just basically said, this was a preliminary matter, meaning the Uber was trying to say, Ontario courts have no jurisdiction here. We have to go to Amsterdam. And the court said, no, we're going to strike down that provision. So things haven't been settled in any way by Heller.
And if I could just monopolize for 20 more seconds. There's a secondary aspect to this case, and that relates to whether or not it was actually necessary to decide that issue, because really the Employment Standards Act question had actually...
But they were avoiding the issue of whether or not these are work employees or not.
I thought they decided that they benefit under the ESA. I don't know, but
I think because that would be a matter of trial. What are these people? Are they employees? So they were not making a decision on that. Whether their employment status. Are they independent contractors or employees? They were only looking at the jurisdiction aspect.
Maybe I didn't understand the first part of the case there, but I had understood that they decided both issues on a preliminary basis in favor of the...
So they take the assumption that their employees can apply the test, but they're not making a decision because this is a preliminary matter. In preliminary matters, the courts are allowed to make certain assumptions to determine the specific issues before them. But they have not said Uber drivers are employees or independent contractors. So they can't necessarily rely on the ESA as a determinative matter and say, well, this is because they're employees. That hasn't been This is just basically a jurisdiction issue. Tamesh, you have your hand up.
I think you may be drifting from the first point on conscionability in terms of, in the first place, it's a question of capacity. What are we talking about? Does the individual, the party has the legal capacity in the sense you're using it, in this case, legal disability. In other words, what
Like
the
the
court
cases.
is looking at is whether they can make a rational decision
Yeah.
in their own interest.
Yeah,
And
like
if
the hearing
that
procedure and
fails,
so on.
right,
Yeah.
if that fails, and that's the point. And even in the first case you mentioned, that may have very well been the issue.
Maybe.
Lack of experience, etc., is a very broad concept.
But it
So-
wouldn't have been a capacity issue in terms of law. That's why I started out by talking about with unconscionability. The cases in Canada haven't looked at, was this person vulnerable in some way? They've gone a bit further. Are they vulnerable because of age? Because of low IQ? There's something more that characterizes the vulnerability and makes it unconscionable.
It all points to a legal disability
Yeah.
in the issue. And even if you're inexperienced, like the songwriter, in a commercial context, and then that leads to imbalance, etc. But one has to zoom into really what are we getting at? I mean, to frame it in the first instance. Is it, are we really talking about a legal disability? Yeah.
Well, that's what I was talking about. If the cases are, using your term, requiring, it seems, legal disability, your term, whereas we couldn't say Macaulay was disabled. He may have been disadvantaged in a loose sense because of inexperience in life, but the Canadian cases predominantly look for unconscionability where you have legal incapacity, again, using your term. And then we kind of come up to Heller, and all of a sudden, it seems like they're using it in a broader way. That you don't have to be someone of low IQ or elderly. You could be an Uber driver.
So the office involved.
Well, that's why I'm asking, how viable is it? Because they haven't made, so,
So if the main.
just let me finish. Sorry, your question again.
Yes, it has changed because I think it leads to significant inequality of bargaining power. So it doesn't require.
But I guess this isn't a decision on the full case. So in litigation, you can have a trial on the issues, but before you get there, you'll have what are called preliminary motions.
So this is not established precedent.
This points in a direction, but it doesn't necessarily definitively answer the question. So it's a motion on whether or not Uber's motion to dismiss this case because the Ontario courts have no jurisdiction to Amsterdam. And they said, no, we can hear it. But they haven't gone into the substantive details necessarily. So it's not saying, it's just saying it can be heard.
So it doesn't.
It's not as authoritative as, say, Turcon, where Turcon makes a decision on this issue.
So we cannot rely on this case.
Yeah, as I said, it kind of points us in a direction that the courts are maybe looking at unconscionability in a broader sense, at least the Ontario courts. Heller talks about an Ontario test as compared to a Canadian test, which I think is kind of confusing. But which adds to the uncertainty as to what is actually being laid down. To Laura.
Yeah, my question is like, since you mentioned that usually the court in Canada like trying to characterize this issue as of like age or whatever reason. So then why you are taking all these cases, for example, the Heller and Hoover and some other cases like my colleague case under unconscionability concept. So since in these both cases there is nothing like incapacity issue, legal incapacity issue, like an age or education or whatever.
Right.
So
But is that what we've been
But the
talking
law
about?
is evolving, and now that can be
So
one
we started
case where
with-
the law evolves.
We started with Macaulay, the English case, which is arguably different from the other Canadian cases.
yeah, but in Heller and Hoover and Heller, so
Because there was no case so far. Now there is a case.
there is no unconscionability issue here in Heller Hoover. If you mentioned that usually the court characterized this concept as a age.
But they did find unconscionability.
So that's what I'm saying, like how it comes, you're saying something and you're saying no, like they did find and there is an unconscionability.
I don't
So
understand
you
that.
said, yeah, you said that like usually court in Canada characterizes
Yeah.
this issue as a age.
Those are the
or
cases you were to read.
Yeah, yeah,
And they say that. I'm not saying it myself.
yeah, but.
The cases are telling us this.
Then
And
in
then
this
we have
case-
Heller.
Yeah, then in this case, they're saying like, although there is no such like such an issue here, of age or education either, but the court said, yes, there is an unconscionability issue. So
Yeah.
How it comes,
And so
how it comes then, like two conflict ideas, like two distinct statements.
Isn't it just simple that that's how were the cases? So the cases which presented in Canada were always cases where there was some disability issue.
and
So
here-
they said that, but it doesn't mean that if they presented with a case where there is no disability issue, what they will say, that's the question. But Heller
Yeah,
will-
I'm
Heller will
posing to you the
ask how
question. So if your opinion is, well, this is too far off of the established cases, that can be your argument,
Especially when we have like some cases like Supreme Court cases.
right?
So how it comes that like court of appeal like overruling or overriding the Supreme Court decision somehow.
They're not overruling because
It's
they
not
can.
like, but
But
it's like, I know
So the
that.
question is, how vital is unconscionability? The question I pose to you. Are we seeing a change in the law? So I'm just going to move on. You had a question, Balkar, I think. had a question.
Now, me? Oh, thank you. So for the clarification of the assignment, the paper, so we need to focus on abuse of power, the bargaining power, the legal vulnerability, you say the legal disability, and what other elements or aspects shall we focus on for the assignment? Apart from the abuse of power, bargaining power, legal vulnerability.
We're not value your
Sorry?
paper.
I don't understand. Like, are you asking for a list of what should be in your essay?
Yeah, just I mean in general, kind of direction. I'm asking just kind of guidance or
Adding
direction.
the word generally doesn't make it so. You're asking for a list, which you just outlined. What I'm saying is, I've never talked about a list. The cases, we've sort of been circling around this for a while. The cases seem to be speaking about what Tamesh called legal disability. Then we have Heller. There seems to be a difference there. Discuss. Balkar.
I was going to say, like, in terms of just clarity, right, if you read like paragraph 74 of the conclusion, so just based on what you said too, the court hasn't taken like a stance on whether or not it is with regard to the individual contractor or employee. So I think they're just kind of just foreshadowing it would be just taking into assumption that if it can be found that they are there to be employees and therefore we can find that there is unconscionability. I think that's what the court's just alluding to.
Yeah.
But basically, what it's significantly does, and the main rationale for that was in terms of the bargaining power, because if the Uber drivers are found to be said to be employees and they're the violation of those employment standards, then it's because of the Ministry of Labor that incurs the cost.
Yeah, so you'll see this with the tort paper. There will be cases that somebody tries to reject the claim that's being made by the plaintiff regarding privacy, and the court will refuse to strike out that claim. That indicates to us that maybe the courts are open to a claim in privacy, but is not definitive that there is a right to privacy.
Can I ask a much simpler question? Are we talking about the entire transaction? When we talk about an imbalance of, of negotiating ability, does it? I'll tell you why. Let me actually. The requirements that the Ontario Court of Appeal lists is one, a grossly unfair and improvident transaction.
Yeah, I have them in front of me.
Is one, and then in its analysis, it refers only to the arbitration clause as representing a substantially improvident or unfair bargain. So I just wanted to check if when we talk about improvidence, are we talking about a particular clause, which seems to be the case in the header decision, or are we talking about, broadly, a disparity between the parties? And
I think that's open. In this case, they refer to something specific because I think that was the issue before them. Can Ontario courts hear this matter? And so they were focused on that forum selection clause.
Yeah.
And that's why they referred to it there. But it seems to be something that can be more open, like what we have with the other cases. That grossly in an unfair and improvident transaction is something that we have seen applied in the, what kind of called legal disability cases.
Macaulay as an example, that kind of the entire...
That could be expanded, there. So, I get the impression everyone wants to go and they don't want to stay for
How about good faith? Good faith is, good faith is
want to stay till
interconnected with the unconscionability.
No.
No?
Sorry.
And then has the last
Just
question.
the last question there.
So if you're upset with not meeting,
I noticed that the judge bore heavily on the Facebook case, the 4 criteria there.
Yeah.
And now the matter is before the Supreme Court. This case is being appealed. Leave has been granted to the Supreme Court. Is that right?
I'm not sure. I haven't seen that it has been.
Yeah, I think it has.
It must have been recently because I haven't seen anything about that.
Right, I've looked at it. And the issue is going to come up because that seems to be the substantive bearing of the judge in the appeal case.
Yeah.
Your views on that?
On what?
On the 4 criteria that was used, the Facebook criteria, which this judge heavily bore on.
My view is that I look forward to your paper. Have a good night. See you tomorrow.